For criminal law procedure. And Kama. Today he will be speaking on military jurisprudence. The major has an undergraduate degree from Illinois State, a law degree from Northern Illinois, yes. A couple LLMs, one from Columbia, and he's currently working on his dissertation, his PhD in law at Columbia. The major is also an associate professor at the U.S. Military Academy at West Point. He's also teaching at Columbia Law School. And I don't know how to summarize your military experience without doing it injustice, but he has pretty extraordinary, some pretty extraordinary work in the area of genocide and military law. With that,
well, thank you very much, ma'am. It's always nice to get an intro before you talk, because then you know you got claps at least once. You know, because then even if you do horrible, you know you at least got some applause. I'd like to start this by basically presenting it the same way as if you were in my classroom, either at West Point or at Columbia. I teach the same way and I follow the same methods and the same rules. So, there's a few rules we've got to agree to before I get started. Rule number one is, after this class starts and the door gets shut, anything that gets said in the classroom, unless it's said by me, can never be repeated. So anything you guys say during a class, none of you can ever quote each other. The idea is that I want you to be willing to say something that's bothering you and not be afraid to say it because you're thinking somebody's going to say, oh wow, what a stupid comment or stupid thing. So our rule is we're never going to quote each other. But if I say something stupid, you can put it on YouTube or whatever you want or anything like that. But so no one's going to quote each other, okay? Rule number one, we have a great deal? Good. Rule number two is that nobody is allowed to interrupt anybody else. Except, there's one big exception, me. You guys can always interrupt me at any time. No matter what. I could be mid-sentence, but you can stop me and say, hold on, I'm not getting this. Or that doesn't make sense to me, or what's the point of this? Or, more importantly, what's probably going to happen is, since I'm talking about some military things, I might use a term or an acronym that I forget to spell out. Stop me and say, hold on, what's that mean? Now, I teach cadets at Military Academy, and I teach law students at Columbia, and telling cadets that they can interrupt me at any time, you know, I'm a military officer, kind of makes them feel uncomfortable. So she introduced me as Major Meyer. And I get called a lot of names, you know, you can be called Major, Professor, or in the old days when a lawyer finished law school, you got the title of Esquire. You know, but ever since Bill and Ted's Great Adventure, William S. something Esquire sort of lost the magic he used to have. So, to make it easier on you guys to interrupt me, so as particularly students, my name today doesn't start with professor or major or anything. As a matter of fact, I'm not even going to use my regular names. I'm going to use a code name. Okay, I'm going to use the coolest name I thought when I was a kid. I always thought the name that was really cool was Steve. So today, at any time you want to stop me and talk to me, just say, hey Steve, hold on. Because Steve's a guy you can interrupt, right? Steve's a guy you can talk to at any time. All right. So what am I going to talk about? I'm going to talk about military jurisprudence. Now, jurisprudence is a fancy word that means the philosophy of the law. And therefore, I'm talking about the philosophy of military law. Now, I'm going to start off with some Maria von Trapp. Anybody know Maria von Trapp?
Yes.
And how Maria von Trapp teaches folks is she says, let's start at the very beginning, a very good place to start. When you read, you begin with ABC, and with this you begin with?
Do-re-mi.
So close! No, belligerency. Belligerency! When you're going to study military law, you start off with belligerency. I don't even know if I wrote it up there right or not. But belligerency is that idea of armed conflict. That weird human experience where people do bad things to each other, and we don't punish them afterwards. And that idea of being able to kill somebody, the idea of being able to destroy something, and damage property without facing any form of negative consequence. As a matter of fact, we put medals on people who do it sometimes, is the idea of privileged belligerency. This is the term that's developed under laws of war. This concept that an individual, if they're in a war and they shoot an enemy soldier and kill him, well, they're not going to be facing murder charges at the end of the war. They're not going to face a wrongful death lawsuit. They're not going to face any consequence for their actions at all under ordinary criminal law. And I think that's the essence. If you're going to understand military law, it all starts with that idea. What I'm going to do is I'm going to make 3 bald-faced assertions here at the start about things I think about with military jurisprudence, particularly with the military jurisdiction. That means what people and acts would come under military law. I'm going to make 3 assertions at the beginning, and then I'm going to try and show you those. Now, we're going to stop dead at 5 till. We may not get through all 3. We'll get through as far as we can, and I'll just round up. I'll summarize, give you the cliff notes of whatever we haven't covered up to that point. But don't feel the need that we need to stay on calendar or on schedule. If you want to stick to a point because I'm just not making it clear to you, I don't mind that at all. Give me the opportunity to try and explain it to you. So, my 3 bald-faced assertions are that criminal law is not equal to military law. And I mean that in the grandest sense, in saying that any similarities between criminal law and military law are incidental. Military law is not in any way derivative of criminal law. It is a totally separate legal paradigm. The second thing I'm going to tell you, this is the one that's going to be a little bit controversial, is that in terms of achieving justice, in terms of achieving the truth, in terms of fairness, military law is the peer, but probably the superior of any criminal system in the world. If your goal is to find out the truth and mete out an appropriate punishment, military law is superior to criminal law, in my opinion. So, in terms of truth, I'm going to put the military law is greater than or equal to criminal law. And again, this is in terms of truth and justice and fairness. And then the third situation, the third assertion I'm going to tell you is that even though I'm going to tell you military law is totally unique and necessary in part 1, and I'm going to tell you that it is superior to criminal law, my third bald-faced assertion is we got to cut it out almost entirely. We've got to eliminate the majority of how we use military law today. So that just doesn't seem to make sense, but I'm just going to draw military law with a great big target sign through the middle of it.
Would you repeat that again, Steve?
Certainly. The idea is that even though military law is necessary and unique, and even though it's superior to criminal law in many ways, we need to shrink it. We need to all but eliminate it as a jurisdiction. Not eliminate it totally, but shrink it down to what its core value is and eliminate what we've been using it for on this side. And we'll talk about that as we get to it. But let's go back to the first one. Criminal law is not the equivalent of military law. And it starts, again, with this concept of privileged belligerency, which happens in between the other two, because this is what makes the difference. There's a debate going on nationally right now between a couple very renowned scholars. Both of them are analyzing Michael Walzer. He wrote a paper called Just and Unjust Wars. And he wanted to analyze the morality of privileged belligerency. And basically, he's looking at the just war concept started by Augustine, analyzed by Aquinas, and it's been looked through throughout legal history. And what he came up with is this equilibrium, equal status proposal. And that is, okay, we're going to have a war here. We're going to have a war between you guys, okay? What's your team name? What do you guys want to be?
They're Team B.
Team B?
Because they got Team B.
The winners? Their title will be the winners. What do you guys want to be?
The Supreme Winners.
The Supreme Winners. All right. So we got the winners versus the Supreme Winners. All right. Now, under modern theories of war, one side is the good guy and one side is the bad guy. I mean, under old theories of war, you didn't necessarily have that, but under modern theories of war, where the only authorized rationale to go to war is defensive, then necessarily one of you is the aggressor and one of you is the defender. So, on a grand scheme of things, one of you is on the lawful war and one of you is fighting an unlawful war. The first hand up gets to the lawful war. Up! So which side are you on?
I'm with the Supreme.
Oh! So the poor benevolent victims that are the Supreme Winners were merrily going about their day, having a picnic in their capital, Whoville, when the evil miscreants winners invaded. And let's assume that the winners are coming in to take your land because they want to own it. They like what you guys have, you know. They don't like who's in Whoville. They just want to control Whoville and have the parties themselves and eat all the roast beefs and sweets and all those things. So their cause under international law is not just. But what about the individual people? Because on a battleground, do I, as the soldier, get to decide whether a war is just or not? Tell me why or why not.
Because you follow your commander.
So, does that mean I lose my sense of judgment?
But it's not your position. You're not called on to make that decision. You're called on to fight.
Who is called on to make that decision?
The superiors.
Yeah, whoever's in control.
Dean Benfield.
No, in the United States, who makes that decision?
President Congress.
Congress declares war. That's right. Although the president can order me to specific actions. But the idea is a fundamental premise of our democracy is civilian control of the military. One thing I can tell you is you never want your military to decide when we should go to war. Because if I get to decide when we go to war, pretty much the only time we're going to go to war is when I know it's only going to take a weekend. I'm going to be able to march in the sun, and the other guys aren't going to be able to shoot at me, and I get to come home and have a parade on Monday no matter what. Because I really don't like the idea of getting shot at. It's just not fun. But in our system, it's not the military that decides when to go to war. So, nor did any of these poor innocents in the military of the Winners Army have any role in deciding, other than maybe voters, to go to war. When you two shoot at each other, does it matter which side is the lawful side in deciding who's being moral and who's not?
I mean, that's subjective. I'm not going to say that we're on the wrong side of anything. No matter who says we're the bad guy, you're always going to take the view that you're, at least at some point, in the right.
But you might subjectively, but I'm saying we're the objective legal community looking at it from the outside, and we're saying that we've determined legally that the winners are not the ones who are right in this war. For example, let's just do a historical analysis. You guys get to be the Allies, and you guys are the Nazis. Okay, sorry, you get to be Nazis. Nazis are just a great example because the last time we had an enemy that everybody agrees was bad. You just don't have anybody saying, well, wait, let's look at it from the Nazi perspective. This doesn't happen. But you guys are just German citizens who are in your military, who were drafted and sent to war. You come across her on the battlefield, and you both draw your weapons and are going to shoot each other, and you shoot at each other. Is there a difference between the morality of what you're doing and the morality of what she's doing?
But is morality different from law, though?
Well, we're going to separate that. Well, first I'm asking a moral question, ma'am, and then we'll address the legal question. You don't think there's a difference in morality?
Oh, you're trying to achieve your end, she's trying to achieve her end.
I'm trying to tell her she's right.
Yeah.
And you try not to get killed yourself.
I think that's the way a lot of people thought about it. And you mentioned the law. What the law says is that under the laws of war, it's developed through the Hague Conventions and the Geneva Conventions, is the idea that if you follow the rules of the laws of war, then you are moral equals, as long as you're following rules of laws of war, which are not the rules of going to war. And let me separate that out with two legal terms. We have jus ad bellum and jus in bellum. Jus ad bellum is Latin, and it basically describes the ability to decide when to go to war. The decision to go to war or not. Jus in bellum is the action that you do after the war has started. When these two are shooting at each other, that's a question of jus in bellum. When we were trying to decide whether the Nazis had the right to invade poor innocent Poland, that was a jus ad bellum question. When I talk about military law and military jurisprudence, I'm talking about jus in bellum. Because I'm dealing with the actions of soldiers on the battlefield. I'm not dealing with the actions of legislatures in voting whether to go to war or not. They still come under their regular laws or international law. They never come under a military law. So I'm dealing with the actions on the battlefield. So we're studying this jus in bello interaction. You guys are shooting at each other. Well, the modern era is to, you pointed out, sir, that you're doing it to defend yourself. And that's part of the reason some people say morally it's justified. The reason you're shooting her is because if you don't, she's going to shoot you. And therefore, that's where we come from. Well, what I'm going to do is I'm going to step outside the U.S. legal paradigm for a second, and I'm going to use German criminal law, just a very basic part of it, because although I'm not trying to promote the German criminal law over ours, the way they separate criminal culpability makes it easier for us to study and talk about it. They have a tripartite system in devising criminal law. Tripartite, 3 parts. What that means is that in order to prove someone guilty of a crime, in order to punish someone for a crime, you have to be able to prove 3 different things. The first thing you must prove is elements. And the second thing is the lack of lawfulness. And the third thing you must prove is the lack of excuse. Now, these are very similar to what we do in our common law system. But they're significantly different in the fact that, for example, when we say someone's mentally insane, they under the McNaughton rule, they don't have the ability to understand the lawfulness, wrongfulness of their actions, or the lawfulness of the consequences of it. Do we still think that they meet all the elements of committing murder?
No, they don't have the appropriate mens rea.
Yeah, they do not have the requisite intent, correct? Because they don't have the ability to form that intent. Well, the way the Germans would approach that is saying, well, the element is just that it was intentional. Did they do it, or was it by accident? So it's just separating it out. And you would meet all the elements of murder if you killed someone as a result of your intentional conduct. Elements are done. They would look into the insanity at a higher stage. They would look at it up here as a period of excuse. So the reason this is a nice paradigm to explore is it separates out elements from justification, that's the lawfulness, from culpability, that's the ability to excuse or not. So if we're going to look at privilege, belligerency, and you two killing each other on the battlefield, if we look at the elements, did you intentionally kill her on the battlefield? Yes, okay? Now the question is, did you do it because you were afraid she was going to kill you. What would that be then? And what is that?
Excuse.
It's a justification, right? Saying it's justified. It is a lawful conduct, so therefore I can't punish you. All right? But excuse is something different. It deals with the lack of culpability. You're not legally justified, but we can't hold you accountable for your actions. And Immanuel Kant, the German philosopher, came up with a good fact on how to analyze this. A ship goes down, and there's a sailor that's holding on to a wooden plank in the open ocean to survive. Okay? And there's another person who is swimming through the ocean and sees the plank. Now, the person who's holding the plank, and that's their only way of keeping from drowning, if they fight off, because let's say that the second person comes and tries to steal the plank. If the person who has the plank initially tries to fight off that individual and in the end forces them off and they drown, thereby intentionally killing another human, we would call that justified, because that's a self-defense that is justified. You can protect your own life by holding onto that plank. But the person who is swimming and drowning, who pulls the plank away from the other person, we can't call that justified. But we aren't going to punish them either. Then we're going to excuse it. We're going to find that they have a lack of culpability. We're going to find that there's some duress or necessity aspect that allows them the moral ability to take that plank from someone else. The difference between justification and excuse is in justification, you're doing what we want you to do from a legal perspective. From on a lack of excuse, it's you didn't do what you wanted. You did something that could be arguably shameful, but still we can't punish you for it. So do we separate out justification and excuse? Do you understand the differences as we analyze it? So now let's put back into our law of war paradigm. A guy by the name of Jeff McMahon came up with a rebuttal. McMahon came up with a rebuttal to Michael Walzer. He said, combatants aren't legal, or equal, excuse me. And that if you are on the Nazi side and you're on the Polish side, your actions are justified because you're defending your country. Your actions as a member of the Nazi army are merely excused. So in other words, they're shameful. You should be ashamed of yourself for being part of it, but we still can't punish you. You know, that's kind of problematic, isn't it? Sir?
Doesn't that go back to the medieval doctrine of the just war, where even someone who took part in the just war had to do penance afterwards?
Took part in a just war, this one, sorry.
Even someone who took part in a war that was proclaimed as just by the church, nonetheless had to do penance afterwards, because what he did was wrong, even though it was excusable.
On the just war analysis, if you think back toward it, was the term actually penance, or was
Yes.
it a form of how do I say it, sacrifice, more of a because on the penance it deals with a confession of a sin and a penalty after a sin,
Right.
whereas I'm not sure it was looked at as sinful conduct, but
It was.
It differed though because they allowed certain people to go to war in Jerusalem as penance for doing other sins.
Right.
So, but if it was Christian nation versus Christian nation, sometimes they did in fact make them do penance
Yes.
after it. But it depends on who you were fighting. It depends on who the enemy was.
Yeah, well, and the church had the last say. If you participated in a war that the church said was just, even so, you could be required to do penance afterwards.
I think
Because the act of killing someone was wrong.
I think that and I'd have to look into that before I give you a more meaningful answer, but when Aquinas evaluated Augustine's proposal, what he argued was that just wars could be fought unjustly, and unjust wars could be fought justly. That's where he was the first one to really separate ad bellum from in bello. My understanding, and this is where I could be wrong, and I need to look into it further based on the question, was that it was for unjust acts in the course of a just war, but not all killing was necessarily an unjust act. I didn't read it as that, and maybe I should go back and look at it again, but that's not.
It's similar.
Okay, I will go back and
Actually,
look
both
at it.
of the semis, the simultaneological
Right.
and the simultaneological, which is a somewhat different background.
But isn't penance something completely different than a legal action? I mean, I understand that the church has some authority, especially then, but that was only an authority that you allowed them to have over you. I mean, as far as if you decided to do the penance, and that was your choice. It's not like, let's say, the king saying, okay, because you fought this war, you have to do X to make up for it.
Well,
I mean, I think those are two different standards.
separating out the moral from the legal aspects to it, I think that, like the Crusades you mentioned, I'm not sure that there was necessarily a segregation between the two because they were both a religious and secular or political cause. Here I am focusing more on the specific of the morality of it, and I have to look into that because that would be an interesting new approach for me to think about. But I think in essence, my understanding, and this is just beyond the Western civilization concept, is that the moral equilibrium thesis was addressed, and that acts of war were not inherently sinful. I think that's the assumption I'm operating under, and I'll go back and look at that. But McMahon once wanted to say that the conduct of the bad side, the Nazi side, was excused. Well, Claire Finkelstein came out and she came up with a counterargument. And she said, no, that's ridiculous. How can you say that there was a moral difference between her action and her action when the difference between the conduct is made by a decision that they had nothing to part of? How could you treat them as anything other than moral equals? The reason you are doing your act and what you are actually doing are identical to her. So how can you treat them as not equal? Further, she said, every society looks at the individual as having a responsibility to serve once they're in the military. So therefore, how can you argue that when acts are excused? You have to argue that they're justified. So she went back to it, basically the best of Walzer in a way. Walzer said, no matter what you decide, they're equal. And he said, fine. Jeff said, no, they're not equal. Some are excused, some are lawful. And Claire Finkelstein is arguing, no, they are the same, and they're both lawful. I have a new approach. I say that we never get to lack of excuse, we never get to lack of lawfulness, because we never meet the elements. My argument, going back to criminal law and military law, are not equal and are significantly different. It comes down to, where does military law come from? The idea of war is the absence of law. It is the total absence of law. Long after civilizations had very developed criminal law systems, they in no way applied those systems to armed conflict. That was a totally unique paradigm. And as a matter of fact, how wars were conducted, as far as being lawful, is a comparatively recent phenomenon. Do you know what the first thing that was ever made illegal under the laws of war was?
No dumb bullet.
What's that? No, that's a little bit farther down. The first one was poison. Now, poison sort of makes sense. The reason they would make poison illegal is because they wanted to make sure whether you were in a paradigm of war or not. If you use poison to kill the enemy, well, poison is not linked to whoever put it in. So if here among the superior winner's side, you suddenly die of poison, how do we know that they did it or that Dean Lawton didn't do it because she just wanted to step into your position? And so we don't know.
We know.
There's some people who are questioning your character. But so the key is, what they wanted to do is clearly delineate armed conflict from civilian actions, which is a problem we're still struggling with today that we'll get to at the end. The second thing that they made illegal was the crossbow. You know why the crossbow was made illegal? Because it was against the laws of God. Because anyone could pick up a crossbow without any training at all and kill a knight. And that God clearly could not want. Yes, sir?
Except that the crossbow was not made illegal until after firearms were available. And anyone could pick up an arquebus and kill somebody wearing armor.
And the French and the Swiss initially argued that the arquebus was also illegal because they said, this is under the concept of the divine right of kings. And pursuant to that, you have the divine right of nobles. God picked kings to be kings, God picked nobles to be nobles. So we have a class structure, and a peasant being able to kill a noble or a king is inherently evil. So we need to eliminate the crossbow, we need to eliminate the arquebus, and anything that levels it out to that, to it. That really doesn't make a lot of moral sense, though, does it? So, if you look, the laws of war were kind of more like a gentleman's club. You know, there were laws that, where you could only fight between during hours of daylight. If you tried to attack the enemy before sunrise, well, that was dishonorable and therefore a violation of the laws of war. Immediately prior to Revolutionary days, it was considered a violation of the laws of war if you attacked the enemy while it was raining, because their powder would be wet, and that would give you an unfair advantage. So therefore, it violated the laws of war. That's not really what law is about, is it? So it wasn't until recently, comparatively, actually tied into where we're at today, that you came up with a moral analysis tied with law for restricting laws of war. Yes, sir?
Well, even in the 17th century, and before that, for that matter, it was considered illegal to conduct an act of war if you weren't acting under the mandate of the state. So that you were hostis homini, you know.
No, I think that's correct. I think that we gradually developed concepts like privileged belligerency. I think you had concepts like messengers, the sacrosanctness of messengers. As a matter of fact, Shakespeare mentions that in Henry V.
It goes back to the Greeks.
Right, and it talks about those were there, but they were not understood as clearly defined. They were just custom. First time it was really written down as an effective code was in 1863 by a guy by the name of Francis Lieber. Now I want to clarify one historical myth. Francis Lieber did not write the Lieber Code alone. He was part of a committee of 5 individuals. The other 4 were all career military officers. And the Secretary of War, Halleck, said, let's create a way to make this civil war civil. You know, because this is a war that's being fought on our own continent. Let's try to make the Civil War civil. And so Francis Lieber came up with General Orders 100. And the first battle the General Orders 100 ever applied to was here in Charleston. And it was analyzing the naval bombardment of the city of Charleston as to whether they could or could not shoot certain areas of the city related to where the steeples were, because they were actually using the church steeples in the center of the peninsula to target in their fire, because that was where the center was. And it was subsequently determined that they should not be using those steeples. The reason I bring up the Lieber Code is if you look at it internationally, most countries in the world still go back to the Lieber Code as being this foundational document where we started expanding what the laws of war really were supposed to be. But Francis Lieber's attempt with the committee was a good first effort, but it still included a lot of things that we probably have some problems with, like reprisals. If you kill prisoners of mine, I get to kill prisoners of yours, and concepts like that. Yes, sir?
Throughout the Civil War, the Union forces were under strict orders not to molest civilians.
Absolutely.
And Grant and Sherman hanged soldiers for molesting civilians.
No, I think that's true, but that was looked at as this is something that is a command measure. Don't do it because I told you, not because don't do it because we must comply with this exterior source of law that is the laws of war. And Lieber, the General Orders 100, maybe not at the time it was written because it was written as General Order, but is subsequently evolved to be this statement of existing law that existed outside, not just because the U.S. said it was, but because it simply was, the idea of customary international law for humanitarian law. And it wasn't until the early 1900s, in 1907, during the Hague Conventions, that these started being refined. And you get the idea of what it takes to be a privileged belligerent reinforced. Now, I got to shift to using a sports analogy. Because now, I'm telling you that there's laws of war as to how war can be conducted. For example, you said, distinction of not killing civilians. Why is it illegal to kill civilians, on the battlefield?
because we say it's illegal.
Yeah, and not because criminal law says it's illegal. And let me clarify this. Let me do a comparison to, say, football. In a football game, why is it that we allow individuals to do violence to each other?
It's fun to watch and drink beer at the same time.
Because we enjoy it, but what's the legal reason why we would allow one person to slam into another at full speed?
They consent, they assume.
Yeah, it's a concept of consent, right? So the default is, no, you can't do it, but we're going to have an exception that's going to allow you to do it. Violence in the civil world is prohibited to achieve your ends unless there's an exception that allows you to do so. As a general rule, if you think about it, any form of violence, the default is prohibited, but here are exceptions when it can be used. Exceptions like self-defense or consent or aspects. Not so in the laws of war. In the laws of war, it's the exact opposite. All violence is legal, authorized, and in some ways required, unless an exception says don't do it. Because the first and foremost concept of the laws of war is military necessity. And to go back to our football analogy, that's like Al Davis, just win, baby. You know, no matter what, the one first and most important rule of war is win. At least that's the way it developed under this concept of military necessity. Yes, you can do violent acts. You can destroy towns. You can burn half the South. Is the way the North looked at it, as long as it was necessary to win. But then, as we evolved the laws of war, we started to say, okay, we still have concept of military necessity, which is still part of the law of war today, but we're going to throw in concepts like proportionality. And that's the idea of, you know, if I'm a military unit and I'm getting fired on by a sniper from the center of Charleston, I don't get to call in a nuclear bomb on Charleston to kill the sniper.
Now, how does Hiroshima and Nagasaki fit into this?
Well, that's an interesting analysis. When you look at the laws of war, and I'll just do a quick aside to answer that, okay? When you look at the laws of war, basically on one side of the equation is military necessity. And on the other side of our, well, let's do it like this. On the other side of our scales, we have proportionality. Proportionality, I'm sorry, I'm horrible at writing this out, plus unnecessary suffering. Plus a concept of distinction. Military necessity is, what did we need to do to win the war? Now, in theory, the idea is that we had to bomb Hiroshima and Nagasaki with nuclear weapons in order to win the war, or in order to gain a military advantage. Not necessarily to win the war, but gain a military advantage at that time. How much advantage did we gain? The reason I did it as a scale is, when you take into account proportionality and unnecessary suffering, you have to, on the other side, it has to be this is greater than this in order for it to be lawful. Proportionality, what I want you to think about is in terms of collateral damage. Who did I kill that was not related to my military advantage? Unnecessary suffering is, what did I do to individuals that hurt them that was not necessary to take them out of the battle? So in other words, like the idea of glass shrapnel. When a hand grenade blows up, little parts of metal go in and will hurt the people around them. Well, they developed hand grenades that were full of glass. What would be the advantage of using glass as a shrapnel? Yeah. You can't get it out. Why not?
Because it's slivers. It's hard to pull it out.
It's non-magnetic.
It's non-magnetic, and you can't see it. And in battlefield triage, it's hard to get out. Now, does this do more to take the person out of the battle? No. If they're full of glass shrapnel, they're not a combatant anymore. What you're doing is just causing them unnecessary suffering. So, aspects, and this is where it's going to key in on when we get to it. But the distinction is the idea you're only allowed to target military targets. So when they hit Hiroshima and Nagasaki, they hit them because under the laws of war at the time, remember this is before the Geneva Conventions, these were military hubs of production. The two cities of production. And,
Like Dresden.
and Dresden is far closer to a violation than Hiroshima and Nagasaki. The firebombing of Tokyo is probably the worst of all, because there you had the greatest amount of civilian damage with the least military advantage gained. Whereas Hiroshima and Nagasaki, comparatively, you had much more of a military advantage. But the difference is, 3 generations later, you were still having birth defects and effects of radiation. That's a lot of unnecessary suffering. So what I would tell you is, in hindsight, it might violate the laws of war. But we didn't know that that was going to happen when we dropped the bombs. So with the knowledge we had at the time, it was probably lawful. But in hindsight, I think there's a strong argument to say it no longer is. If that answers. Okay, sir.
There were conventions going way back. For example, you had to wear a uniform in order to commit a military act.
Right, that's actually part of the Hague Convention of 1907.
But it goes back to the 17th century. I mean, that's why Nathan Hale's happened.
Let me clarify that. What allowed you to kill an enemy who was in civilian clothes, this concept of perfidy, is not based on the laws of war. That's based on criminal law. That is, it's because an individual was a spy. An individual was, and this is where it gets confusing, but those aspects. Let me use a factual example that should clear it up for you. I'm taken to prison, and I am a prisoner of war in an enemy POW camp. Now, I am now, under the laws of war, a non-combatant. I want to escape. I kill the prison guard, and I escape back to the American lines. Under the laws of war, I did nothing illegal. Under the laws of the country that was holding me, I committed murder. For all time, I violated their domestic laws of murder, their criminal law. And 10 years after the war's over, if I go on a vacation there, they can arrest me and charge me with murder. This is where criminal law and military law are just like 2 different realms. I can be a hero because I escaped and came back to the US and they can put a medal on me, all the while knowing that if I return to that nation, I can lawfully be prosecuted for murder, for killing that guard, because I killed him while in the position of a non-combatant. All right, we spent a little time on this, and I realize I've only got about 5 minutes left. We're still at the first point, but I warned you up front that I didn't think we were going to get to the third point, and I wasn't sure how far we get into the second. So what I'd like to do, if it's okay with you guys, is I'm going to go to Cliff Notes version for a little bit to try and round things out so you understand where I'm coming from. What I was trying to explain as we went through the laws of war and the laws of belligerency is that the paradigm of war operates outside of the criminal law realm. H.L.A. Hart, when he said, this is where the source of law comes, he said, let's start with primary rules. Every civilization operates under what he called primary rules. Don't kill, don't steal, don't lie. Those don't apply to war, and didn't apply to war thousands of years after they applied to other aspects of civilization. So the idea of trying to apply other aspects and theories and morality of criminal law to war just doesn't make sense. It is criminal law is a very, very restrictive society as far as violence, whereas war is a very, very permissive society. So there is a different realm of law that is military law. But soldiers still get prosecuted for crimes. 2 types of crimes. They get charged for war crimes, crimes on the battlefield, which is the essence of military law. But ever since the Supreme Court case in 1987, U.S. v. Solario, the military also has jurisdiction over all civilian crimes. If a soldier gets in a bar fight in downtown Charleston, the military still has jurisdiction to prosecute them under military crimes, or under the Uniform Code of Military Justice. Now let's shift real quick to this, where I'm going to argue that military criminal law is superior to civilian criminal law. Under grand jury proceedings, ma'am, what rights does the defendant normally have?
None.
They might not get any notice. You know, the first thing they know that happened was the service of the indictment. Under military law, you'll not only get notified that this, we call it an Article 32 proceeding is happening, you have the right to be present, you have the right to be represented by an attorney, you have a right to cross-examine all government witnesses under oath, you have a right to call any witnesses you want and cross-examine or examine them under oath. And all of this is recorded and sworn testimony. You know, the hard and fast rule of court is never ask a question you don't know the answer to. Well, in the military, you can ask that witness the question 15 different ways. Why? Because it's not part of the trial record. It's your test shot at the witness to evaluate it. So oftentimes in a criminal law system, the defense lawyer's access to a government witness before trial, I mean, you might be in the same room with them, but how much they're going to help you out or talk to you is relatively limited depending on what the relationship is to the victim. Well, here you get to do it under oath. It's like that free deposition of everything. And if you ask the question and you don't like the answer, well, then you're not going to ask the question that way in court. You're going to ask it a different way. So the ability for the defense to have a full understanding of the case against the defendant is far greater just as a result of that one administrative proceeding. A second thing is, in military law, we have the luxury of focusing purely on justice. Who makes the decision on whether a case goes to trial in civilian law?
District attorney.
The DA. Who makes the decision on how it's going to be tried? So again, the DA. Who makes the decision on whether to receive a plea agreement? DA. Who makes the decision on whether to give leniency after the trial? Again, it comes down to a DA. All based on one lawyer. Most of the time, an elected position. Now, I've looked at little cards about DAs. Yes, sir.
But isn't that unique to the American system? In civil law countries, none of that happens.
I fully agree with you, but and I should have clarified that right now I'm focusing purely on the American experience. In the military, the prosecutor gets to decide how to try the case. That's the only discretion the prosecutor has. It takes a commander to decide for something to go to trial. As a matter of fact, normally it takes 4 commanders, all agreeing at different levels. The company, battalion, brigade, and division commander, all agreeing that this should go to trial before it will go to trial. In theory, the division commander can send them all by themselves, but normally the process is through all 4. Plea agreements are not decided by the lawyers. Now the DA, when they're running for office, what's it say on their little bill of what they're bragging about? Conviction rate. Conviction rate. So how do you achieve a 96 or 98% conviction rate? Yeah. 1, you plea out everything you can. 2, you never take the case to trial unless you are absolutely convinced it's going to win. Now on the one side, I said on the Article 32 stage, this is an advantage for the defense. When we come to the charging decision, this is an advantage for the victim. In the military, we are far more likely to take a case to trial that we're not certain is going to win, only because we believe that yes, the crime occurred and the victim deserves a day in court, and let's allow the system, the jury, the judge to make the decision, and not the prosecutor. There's no conflict of interest of, oh my gosh, if I take this and lose, it's going to weigh negatively on me. As a matter of fact, as a military prosecutor, my wins and losses are irrelevant. It's my performance in the courtroom. To the extent that when I prosecute cases, if the defense lawyer is about to make a mistake in court, I'll often hand him a note. If he says, we call this person, I've handed the defense lawyer a note saying, you realize if you call this person, you're opening the door for me to bring this, this, and this before the trial. And if they want to do it, fine. But sometimes they're like, oh my gosh, I didn't realize that. Your Honor, we changed our mind, we're not going to call them. Or maybe their whole defense is alibi. I've had this case before where it was a civilian defense counsel. Their whole case was alibi, and yet they rested, the defense rests, when they had not called their alibi witness. And so I handed a note. I said, are you sure you want to rest without calling this person? Oh, we'd like to reopen our case. And of course, the government didn't object. Why? Because I'm supposed to be, as the prosecutor, focused on one thing only, justice, not about winning or losing. In the military, we are focused purely and simply that we don't want the lawyers to decide the case. In other words, I don't know if I could sleep at night if I thought that an individual was convicted because I was better than the other attorney. I want the case to be cited on evidence and the law. And so we do everything we can to bring that about. Finally, the last thing is the jury or the panel itself. A civilian jury, what's the biggest problems we get in convictions? When we find that maybe the innocent might be convicted or the guilty are given a far, sentencing isn't there, but where we question the result as a result of what the jury found.
Emotion.
What's that?
Emotion.
Emotion because of factors they shouldn't be including, like racism, various forms of prejudice, sexism. What's the enemy of those? What's the enemy of racism and sexism and other acts of discrimination? The enemy is education. Now, one thing about a military panel is, at a minimum, 2/3 of it have a college education, normally much higher than that. And, more importantly, military follow orders. When a judge says, don't include this in your rationale when you reach a conclusion, they actually don't, because they follow orders.
But how do you know that? I mean, how,
When we,
jurors are presumed to follow the law as well.
In a military jury, after the verdict, I can never ask anyone they vote, but I am permitted to ask them, you know, what mattered to you, what did you focus on, what was this? And I can tell you just anecdotally, they've said, you know, that one piece of evidence, if I could have included that, they were guilty. But I couldn't do it. I wanted to, but I couldn't. Sir?
Typical court martial.
Yes, sir.
What are the juror qualifications? What kind of people are they? Are they all officers?
The default is they must all be officers. However, we actually sort
I'll
of
take
follow.
that.
What's that?
I'll take that.
Well, the default is all officers, except if you are an enlisted defendant, you can require the court to make 1/3 of the jury enlisted. That's your right, and you get to pick it.
It's different when you're picking them from list of who can get a driver's license and who can get a right to vote. That's a
true.
different group of people.
Now, I think the reason we're able to do these things is because we don't have the resources limitations necessarily of a district attorney. We have a very, very good cause. We spend a lot of time teaching people how to try cases, and we really spend a lot of time making sure each one is done right. I don't think a DA could ever do that. But the question is, should a soldier who gets into a bar fight with a civilian in the middle of Charleston face this much fairer justice system than the person he fought with, just because he happens to be a soldier? The person he got in a fight with goes before the DA, and the DA is of a situation of, I was a public fight, I'm going to plead the case out, but if you don't take the plea, we're going to go to trial because I know I've got it, and I know it's going to be a conviction. Whereas, let's say, hypothetically, the soldier is, before this more advanced situation where he has more access to evidence, is able to defend himself and get an acquittal. Is that fair? More importantly, is it required by the military mission? I don't think so. I don't think we need to extend jurisdiction on the military when they're outside of the military mission. I think that the core essence of military jurisdiction is based on subject matter and location. When we are away from the United States at war, that's when you need a military jurisdiction. We also, I don't think, necessarily need a military jurisdiction to prosecute civilians that are attempting to do acts of war against us. I think our analysis on the military commissions has been up to this point, are they legal and are they the best choice? And if the answer is yes to both, we use them. I'm going to go back to, should we use them? Are they military? Because the military courts should not be courts of convenience where let's use them because they're going to do a good job or because they're going to allow us to do things a certain way. They should be courts of necessity. We're only going to do it when we can't do it through any other system. That's why we can hold on to making this high standard because we know that when we put individuals in a situation where other people can legally kill them, we want to give them a little bit more protection under the law. So that's why I come down to the end that even though military law may do it better and it is unique, I think it's something that we need to shrink. I think we need to hold that dear to when it is only military necessity. Let me just say one last thing for the question, if that's okay. This is not a novel idea. The Supreme Court, when they were analyzing In re Milligan, right after the Civil War, it's interesting in opinion because when they were writing the opinion, one of the little footnotes points out, you know, the guy we're talking about might already be dead. When they were actually deciding it, they had no idea whether he was alive or dead, and there is no military record whether Milligan was executed or not. But it was probably that he was executed before the opinion came out. Well, they said if the civilian courts are open and operational, then you can't take them to a military court. I think what they are saying, and the real message is, if it's not a necessity to take it to the military court, because there's another option, then it shouldn't go to the military court. If there's another option that can do it, then that's where it should go. And I want to just get back, simply put, to where that is. Allow soldiers to do what soldiers do best, and don't try and make us expand our mission, because whatever you give us, if you tell us we're supposed to sell shoes at the mall, we're going to learn how to do it and do it to the best of our ability. But that's not why we exist, and that's not why we have this special privilege to be outside the realm of law. Let me go back to you.
Well, instead of the Charleston example, which is is easy for us to see. Sure, not really fair for the guy in the bar fight in Charleston who's not in the military to have to go through the civil system, and the service member goes through this military system, which possibly benefits them. What if they're in a bar fight in Iraq or in Afghanistan or in Pakistan? Do we put our military then through the civil criminal systems in those countries instead of through military process?
The answer to that question is the same answer that any lawyer gives you if you ask them a question. What's that? It depends. No, that is a question between states. And we do status of forces agreements where, for example, in Korea, if the victim is a Korean, we share joint jurisdiction, but they get first chance at it. And if and only if they don't want to prosecute it, do we then prosecute it. But that is something we negotiate. But remember I said it is both subject matter and location. If we're outside our borders, then, yeah, I think it makes more sense for us to start using military jurisdiction. That's where it started, was the idea that it was a jurisdiction that traveled with the soldiers. And so I agree with you that in that situation, and particularly in Iraq, we absolutely do not allow currently any of our soldiers to go to any court in Iraq. 10 years from now, we might negotiate something different if we believe in their system. Yes, sir?
What about a fight between two military members on the military base in the bar, you know, if you have a bar on the base, would you handle that purely as an intermilitary thing or treat it under the civilian laws?
Yeah, we are.
It's one I'm going to allow people that need to go to.
Yeah, I said I'd shut down at 5 till and I blew that time, so I apologize everyone. But I'm here for as long as you need me. But in answer to your question, I still go back to it depends. In the United States, we have two different types of installations. Some are federal jurisdiction exclusive. For example, Fort Huachuca, Arizona, the state jurisdiction in Arizona does not apply on Fort Huachuca. Only federal law applies. So therefore, the question is, does it go to a court martial or the federal district court if the state doesn't apply it? But I would tell you that regardless of that being an aspect of current law, my answer would be crimes that are of a military nature. So for example, is it just a bar fight between two individuals fighting over a girl? I don't think so. But if they're in the same unit and it affects the unit, then maybe. And so the core essence is, you know, think about it. We put people in jail for showing up late for work, you know, and if you try to leave work early, we've killed you. You know, I mean, in essence, historically. So we do have unique rules as to what it takes to be a successful fighting force. I'm just saying that our jurisdiction should be constrained by when we need it, and not just when it can be used.